now recognize the gentleman from Illinois, Mr. McClory, for 15 minutes for purposes of debate only.
Thank you, Mr. Chairman. I judge from the remarks of the gentleman from Massachusetts that indeed he has come to a resolution of this momentous question that's before us. Nevertheless, Mr. Chairman, let me express the view that this impeachment inquiry undertaken by our House Judiciary Committee has been both historic and honorable. Impeachment is, of course, a political process, both political in the sense of governmental action and political in that it involves partisan interests and views. It would be the grossest understatement on my part to suggest that Watergate and all that that word implies has not caused serious injury to my party, the Republican Party. And this is so despite the fact that no element of our established Republican Party organization was involved, and no Republican member of the Congress has in any way been implicated in this whole affair. Let me assert, on the contrary, that Republicans, even more than Democrats, are anxious to erase this blemish from our party. I've heard it said by some that they cannot understand how a Republican could vote to impeach a Republican president. Let me hasten to assert that that argument demeans my role here. It would infer that no matter what high crimes and misdemeanors might have been committed, that if attributable to a Republican president, then I, as a Republican, am foreclosed from judging the merits of the case. I cannot and do not envision my role in that dim light. As a purely partisan matter, would it enhance our Republican Party if, despite the evidence and the weight of constitutional law, we as Republicans on this side of the aisle decide to exonerate a Republican president accused of high crimes and misdemeanors simply because he and we are Republicans? I see that line as leading to Republican Party disaster. A viable two-party system, to my mind, is an institution worthy of preserving, second only to our constitutional system of checks and balances. Preserving our Republican Party does not, to my mind, imply that we must preserve and justify a man in office who would deliberately and arbitrarily defy the legal processes of the Congress, nor can our party be enhanced if we, as Republican members of the United States House of Representatives, tolerate the flouting of our laws by a president who is constitutionally charged with seeing to that the laws are faithfully executed as provided in Article 2. We will enhance our Republican Party and assure a viable two-party system only if we are courageous enough and wise enough to reject such conduct, even if attributed to a Republican president. The essential question which we must answer is not what is best for our party, but what is best for our nation. While the investigation has been far-reaching and has, in my opinion, delved into some peripheral areas, I cannot help but recognize that on the major subjects which have been investigated, the work of the committee and of our committee staff has been both objective and bipartisan. I would like particularly to observe that we've been assisted by able counsel, and to make a general observation that the members of the minority staff, the Republican staff, have contributed substantially to the overall work product of our inquiry. Despite our partisan differences, I would add that you, Mr. Chairman, have, in general, been very fair with the minority. The American public need have no fear that the Republican interests have not been ably and appropriately served by our ranking member, Mr. Ed Hutchinson of Michigan, and by my other distinguished and able colleagues who sit on the Republican side in this committee room. I shall turn at once to the main subject of our inquiry, namely the numerous allegations of wrongdoing charged against the President of the United States, all of which allegations we have investigated over a period of many months for the purpose of ascertaining whether or not President Nixon should be charged with the commission of an impeachable offense. The most serious allegations, and those upon which the President's accusers have placed principal reliance, go under the general title of Watergate and cover-up. Our majority counsel, Mr. Doar, in interpreting the information before us, has expounded the thesis that the President organized and managed the Watergate cover-up from the time of the break-in on June 17, 1972, up until the present time. While serious questions exist regarding the President's authorization or acquiescence in an obstruction of justice, a conclusion which might be reached from examining the transcripts of taped conversations and other evidence, the thesis advanced by Mr. Doar that the President was in charge of a cover-up from the time of the break-in is, in my opinion, unjustified in the light of the evidence presented to our committee. Our Chief Minority Counsel, the able Mr. Sam Garrison, made an important and extremely significant point in his final summation of the Watergate evidence. He said, Mr. Doar's case of circumstances showing presidential involvement from the beginning is a very, very weak one, because you cannot simply aggregate suspicions, you cannot aggregate inferences upon inferences, you can only aggregate facts. Watergate is a serious matter. Many in and out of the White House have been involved in this tragic episode. But while voluminous evidence has been produced, I question seriously that it is of the clear and convincing nature that should impel us to indict the President on a charge of cover-up or obstruction of justice. Instead, the case against the President rests upon circumstantial evidence, inferences, innuendos, and a generous measure of wishful thinking on the part of some who would indict the President even without adequate proof of wrongdoing in the Watergate affair. Now, in the light of today's Supreme Court decision, there may be indeed other available evidence to the committee within the next few days or weeks. Substantial additional evidence from the White House tapes upon which this committee can better judge the guilt or innocence of the President in the whole Watergate affair. The doctrine of absolute executive privilege upon which the President and his counsel relied has been substantially rejected by the Supreme Court. And we can expect, hopefully, that we will get promptly and without equivocation from the White House the additional tapes which we also subpoenaed and which are now under the President's decision to be made available to the special prosecutor. And we also have the mechanism for excising those irrelevant parts which might not be appropriate for us to see. Although on the basis of evidence thus far received, the case involving Watergate has been less than convincing, there are other subjects in which the facts are virtually undisputed, and where the only unsettled question is whether or not an impeachable offense has been committed under the Constitution, to which I made reference. If the extremely serious subject of Watergate results nevertheless in a weak case against the direct involvement of the President, this should not be construed to mean that there has been no wrongdoing in the White House. Watergate and the alleged cover-up involves the offense of obstruction of justice, for instance, payments of hush money, inducing witnesses to commit perjury, and others. These offenses have been committed at the White House or by the President's most intimate aides and friends. But if the President is not personally and criminally liable because the evidence does not directly and personally implicate him, nevertheless we may appropriately ask, has the President fulfilled his obligation to see to a faithful execution of the laws, a solemn obligation imposed by the Constitution? This obligation is above and beyond that of other citizens, all of whom are required to obey the laws. We may ask further, is the office of the presidency being operated in the manner contemplated by the Constitution when, under the guise of national security, dissatisfaction with the head of the FBI, or personal animosity against enemies, we experience burglaries, wiretaps, bugging, unlawfully provided, shredding and concealment of evidence, misuse of the CIA, FBI, IRS, and a host of other misdeeds? It should not be hard for my solid Midwest constituents, Republicans, Democrats, and independents alike, to see and understand what's troubling me. Believe me, it's also troubling them. The question remains whether these acts and omissions of Richard Nixon as president are to be approved or denounced. If in these respects the President is to be denounced, and if the President is to be called to account for such acts and omissions, impeachment is the appropriate and constitutionally designated vehicle for bringing these specific charges against him. What about the offenses committed by Haldeman, Ehrlichman, Colson, LaRue, Dean, and others. There is substantial authority for attributing their misconduct to the President in a strictly legal sense and require him to account for their offenses. But there's the higher constitutional obligation to see that such criminal acts are not committed or condoned, a constitutional demand to see that the laws are obeyed, particularly in the President's own house, which we call the White House. After receiving evidence for weeks and weeks, evidence which has been frequently peripheral as it relates to direct involvement of the President in Watergate and other crimes, I ask myself, is this any way to run a White House or a country? Finally, the clearest and most convincing issue before us, and one which is perhaps more fundamental to our inquiry, is that of the committee's subpoenas, in which we requested information from the President. Fundamental to the entire impeachment inquiry is his obligation to provide us with the information which we require so that we can perform our role. We do want a strong chief executive, but we also want a Congress which is given full recognition, as well as the courts. Likewise, it's essential that the President respect that part of the Constitution which vests in the House the sole power of impeachment. The House Judiciary Committee, as the designated unit of the House of Representatives, is endeavoring to fulfill that role with honor and dignity consistent with our responsibilities. In this particular time in our history, we demand a Congress capable of exercising not only its lawmaking authority, but also its power of the oversight function, which includes that of the extraordinary authority of impeachment. Earlier this year, the President promised full cooperation with our inquiry, consistent with his responsibilities to the office of the presidency. But despite that pledge, the only materials which we've received have come from the grand jury and from the special prosecutor, except some that have accidentally fallen into our hands. On May 30, we sent the President a letter advising him what the consequences were of his failure to comply. We said, in meeting our constitutional responsibility, the committee members will be free to consider whether your refusals in and of themselves might constitute a ground for impeachment. The committee has taken this stand because of the President's noncompliance with the committee's subpoenas, a defiance of the powers of the Congress, and impairing our ability to preserve, protect, and defend the Constitution of the United States. In this sense, it seems to me the President's failure to comply threatens the integrity of our impeachment process itself. His action is a direct challenge to the Congress in the exercise of its solemn constitutional duty. These, then, are the issues which are disturbing me as we approach this final phase of our assignment under the House resolution authorizing this comprehensive impeachment inquiry, which my colleagues and I have been conducting, and which we must resolve deliberately and responsibly within the next few days. Thank you, Mr. Chairman.